Recently, Blake Lively filed a motion for sanctions against Justin Baldoni and the Wayfarer party's lead attorney, Bryan Freedman. This came shortly after Blake Lively had gone after the law firm trying to obtain privileged information or things that were covered by the work product doctrine, which was shut down by the judge. Blake Lively says that Bryan Freedman has been a part of this smear campaign, acting as an agent for the Wayfarer parties, and has been actively defaming her in the press. The Wayfarer parties have now responded to Blake Lively's motion for sanctions against Bryan Freedman, so let's take a look at what they had to say. In her latest effort to curtail opposing counsel Bryan Freedman's speech and chill his ability to effectively defend his clients, plaintiff Blake Lively now seeks a laundry list of sanctions under Rule 3.6 of the New York Rules of Professional Conduct. Now, there's definitely a pattern of Blake Lively trying to chill speech. I've been on the receiving end of it, as were 106 others who had negative things to say about Blake Lively online. A lawyer has a right, indeed an obligation, to defend his or her client, even in the press. Ms. Lively nevertheless insists that Mr. Freedman was the architect of a far-reaching scheme to smear Ms. Lively. Ms. Lively points to 10 statements in which Mr. Freedman questioned the validity of Ms. Lively's claims, addressed the possibility that Ms. Lively would continue her deposition, which she did, and referred to Ms. Lively as a Hollywood elite, which of course she is, having worked her whole career to become. Ms. Lively contends that Rule 3.6 applies because Mr. Freedman's statements challenge her character, credibility, or reputation. Ms. Lively misconstrues Rule 3.6, which does not bar public statements by counsel, even statements critical of an opposing party. Rule 3.6 bars only those statements that create a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The chief failing in Ms. Lively's motion is the underlying assumption that any statement that touches on a party's character, credibility, or reputation automatically triggers a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter, and therefore violates Lauren. And therefore violates Rule 3.6. This is not the case. So one thing I noticed, obviously, was they make this huge deal about things that are critical of an opposing party's character, but then they say all these horrible, terrible, damaging things about Justin Baldoni in the press, and that's fine. Nevertheless, Ms. Lively glosses over the threshold requirement for Rule 3.6 sanctions, which is that the negative publicity creates a substantial likelihood of materially prejudicing the adjudicative proceedings. Ms. Lively deftly sidesteps this requirement with a single conclusory statement: "This court should impose sanctions here because Mr. Freedman's statements pose a significant risk of tainting the jury pool with deceptive, corrosive, and untrue statements cloaked with an illusion of lawyerly integrity." Ms. Lively does not argue, much less provide any evidence, that Mr. Freedman's statements are likely to taint the jury. Ms. Lively does not enlighten on the significant risk or explain how comments made 8 to 11 months prior to trial could pose a significant risk of materially prejudicing the jury, particularly here, where the jury pool consists of literally millions of residents in the New York metropolitan area. Instead of enlightening on the risk of potential prejudice, Ms. Lively myopically focuses on the second part of the analysis, namely whether Mr. Freedman's comments relate to Ms. Lively's credibility, character, or reputation, which may ordinarily create prejudice. An analysis that is unnecessary absent a showing of substantial risk of materially prejudicing the adjudicative process. Ms. Lively's failure to demonstrate a substantial risk of material prejudice alone dooms Ms. Lively's latest request for sanctions against opposing counsel. Moreover, even assuming that Ms. Lively's silence is sufficient to establish a substantial likelihood of materially prejudicing an adjudicative proceeding flowing from any statement made by Mr. Freedman, the cited statements fall under Rule 3.6's explicit exceptions, including, among others, the exception for statements a reasonable lawyer would believe are required to protect the client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client, which is necessary to mitigate the recent adverse publicity. In this vein, Ms. Lively conveniently ignores her own counsel's very public campaign to savage defendants and their counsel in the public eye. Ms. Lively similarly ignores that she was a highly divisive figure long before Mr. Freedman came on the scene. Discord on the It Ends With Us set attracted media attention while the film was still in production. Public and media interest spiked when Ms. Lively encouraged cast and crew members to defriend or unfollow Mr. Baldoni on social media, froze Mr. Baldoni out of the marketing campaign for the film he produced, directed, and starred in, and banished him and his family to the basement at the film's premiere in August 2024, long before Mr. Freedman was engaged in late December 2024. Ms. Lively herself poured fuel on the fire when she and or her counsel provided a draft of her CRD complaint to the New York Times before it was filed. Ms. Lively's post-litigation conduct has done nothing to endear her to the public, the press, or content creators. Well, I can attest to that. A lot of us just had to make a public filing in federal court explaining how we came to not like this woman organically because she was trying to obtain our personal and private information for speaking poorly about her online. So no, she hasn't done anything to endear herself to the public or content creators. A recent barrage of subpoenas has angered and alienated those already critical of Miss Lively, forcing a number of them to seek this court's intervention. And the footnote here says, to the best of the Wayfarer party's knowledge, the subpoenas have failed to yield any evidence of manipulation or interference by Mr. Freedman. That is correct. As soon as anybody fought back, they withdrew the subpoenas very quickly, ostensibly so they could avoid those requests for sanctions and a protective order that we all made. But what can I say? These people are scummy. Blissfully tone-deaf to her own conduct, Miss Lively is not only unwilling to accept that her own celebrity and actions have generated the media frenzy she now complains of, and the weight of negative publicity against her. She conveniently ignores that she and her counsel have been less than shy about publicly bashing Mr. Freedman and the Wayfarer defendants in the press. Nevertheless, Miss Lively seeks monetary sanctions, attorney's fees, a reprimand, and revocation of Mr. Freedman's pro hoc vice admission for statements primarily relating to whether Miss Lively would appear at deposition and the falsity of her claims. In short, as explained below, Rule 3.6 does not, as Miss Lively urges, render any public statement by a lawyer sanctionable. While statements that relate to a party's character, credibility, or reputation may be ordinarily likely to create prejudice, the statements must also create a substantial risk of materially prejudicing the adjudicated proceedings. In other words, ordinarily does not translate to absolutely, and the fact that a statement may relate to a party's character, credibility, or reputation does not abrogate the requirement that there be a substantial risk of material prejudice to the adjudicated proceeding. As elaborated below, Miss Lively's motion should be denied because 1. Miss Lively fails to show that Mr. Freedman's statements raise a substantial risk of materially prejudicing the jury, and 2. The statements identified by Miss Lively fall into Rule 3.6's express exceptions for statements concerning the claim, offense, or defense, information in a public record, scheduling matters, and most importantly, statements that a reasonable lawyer would believe is required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client to mitigate the recent adverse publicity. Now they're going over the history of publicity relating to Blake, and it ends with us. Miss Lively is a celebrity who, for whatever reason, has long been a magnet for media attention. During production of the popular film It Ends With Us, well before the alleged smear campaign, rumors of discord on the set were swirling. By August 2024, roughly the time when the film was released, the rumor mill about troubles on set were already receiving significant media attention, and both sides had retained public relations consultants. Public scrutiny of Miss Lively's conduct accelerated after she urged her followers to defriend or unfollow Justin Baldoni on social media, froze Baldoni out of the marketing campaign for the film he produced, directed, and starred in, and banished Mr. Baldoni and his family to the basement during the film's premiere. Miss Lively points to a chart showing an increase in negative publicity beginning in early August 2024 and spiking on August 9th, 2024, the day the film was released, a natural point for a spike in public comment. I know that was probably like a PR thing, but this lady totally strikes me as someone paranoid enough to have just like charts of herself where she's like looking at what people are saying and when they're watching. Miss Lively further fueled the already brewing firestorm by leaking her CRD complaint to the New York Times in advance of its December 20th, 2024 filing. The complaint contains sensationalized allegations of sexual abuse and misconduct on the set of the film. So people say that it's a sexual harassment allegation, right? Not a sexual abuse or assault allegation. However, the stuff that they described in the initial complaint and in the amended, I believe, that does describe sexual assault. So while they can kind of cop out and say, well, we didn't use that word, what you described was absolutely sexual assault. It was also absolutely not what happened, as you can see in the footage that was released. As part of Miss Lively's very concerted efforts to shape the public narrative and sway potential jurors, Miss Lively and her counsel have routinely exploited the media to advance their version of the facts. Miss Lively's efforts to influence public opinion, primarily through her counsel, continue unabated. Nevertheless, Miss Lively contends that the Wayfarer parties and Mr. Freedman's efforts to counter the hurricane of negative publicity are a smear campaign which violates Rule 3.6. Then they're talking about Miss Lively's relentless campaign against Mr. Freedman. There's a footnote here that says on August 8th, which was like a little over a week ago, this court wisely issued a long overdue order advising all individuals filing documents in this case not to make submissions using language that is disrespectful to the parties, their counsel, or the court. The Wayfarer parties are hopeful that all parties will comply with this order and cease from the incessant personal attacks on counsel. And if you guys remember, Perez was pretty colorful in his letters, and then that order was actually made sometime after that. Like he said, he was kind of speaking his mind freely, and then if the judge, told him to knock it off, he would knock it off. And he has, and he's continued to represent himself. So we wish him the best of luck with that, of course, and he's not done. So After the film's release, this motion is the latest salvo in Miss Lively's relentless war against Mr. Freedman. It comes on the heels of a string of motions calculated to intimidate counsel and curb Mr. Freedman's statements in defense of his clients, including a Rule 11 sanctions motions against the Wayfarer parties and their counsel, and a subpoena directed to Mr. Freedman's law firm seeking, among other things, all communications and agreements with content providers from July 2024 to the present. But this is not all. Miss Lively sought to bar Mr. Freedman from taking Miss Lively's deposition. This was really early on, and you don't get to pick which lawyer takes your deposition. That was probably one of those things Megyn Kelly was alluding to when the general public is like, wow, you're kind of an entitled bitch. Because she thinks she's above everyone and she gets to have everything her special way. All right. And has repeatedly added gratuitous swipes at Mr. Freedman in a string of motions unrelated to the negative publicity which Miss Lively alleges smeared her. In this latest assault, Miss Lively cites 10 statements by Mr. Freedman issued between February 5th and June 11th, 2025 as violative of Rule 3.6. So we've already seen most of these, but I'll run through them really quick. The first was that Blake and Ryan were going to probably take some legal actions that are beyond the bounds of decency, and we'll see if they can try to avoid a deposition. So they definitely have done that. Think about the Van Zandt lawsuit. That's sketchy as hell. The subpoenas to 107 content creators, many who were probably not even notified. And those are only the first things that come up to my mind. The second one was when he said, documents don't lie, people do, and I wouldn't want to be on the wrong side of history here. Third, he said, Miss Lively's claims are false, filled with unsubstantial hearsay of unnamed persons who are clearly no longer willing to come forward or publicly support her, and lacking actual evidence as documents do not lie and people do. Next, he said to TMZ that Miss Lively's motion to dismiss was an attempt to cover up for the self-concocted disaster she initiated. Well... And Miss Lively was a privileged elite whose motion to dismiss twisted and curated the law to fit her personal agenda, and one of the most abhorrent examples of abusing our legal system. Again, I agree with that. Honestly, not even thinking about the motion to dismiss specifically. I'm just thinking about the whole damn thing. The Van Zandt thing, the attack with the New York Times, all of it's been a disgusting mess. An April 4th statement to TMZ that Miss Lively was attempting to divert the public's attention from the receipts, the actual documents, video footage, and additional evidence, which Mr. Freedman asserted made it irrefutable that there was no sexual harassment, that Miss Lively's own conduct caused the organic backlash she received, and Miss Lively does not need discovery to find out who smeared her, just a mirror will do. I'm sorry, that's awesome. An April 4th statement to People magazine that Miss Lively belonged to a circle of Hollywood elites seeking to advance false and harmful claims and block access to the court system and weaken our nation's constitution to service those who are in positions of power. The May 8th statement to People magazine that there was so much interest that Miss Lively's deposition should be held at Madison Square Garden and to sell tickets or stream it. Again, that's one of those things where, like, if I was the client, I would wish he hadn't said that, but it was clearly not a serious thing. A June 10th statement to TMZ that Miss Lively was afraid of the truth, and we're going to see if she's going to appear at the deposition or not, and then Miss Lively filed a lawsuit which, accused some very good people of a smear campaign, and accused, a terrific young man of sexual harassment. That's not even, like, really saying bad things about her. It's just saying nice things about him, mostly, A June 11th interview on Megyn Kelly's podcast in which Miss Kelly, not Mr. Freedman, stated that Mr. Freedman is waging war against Blake Lively, who he believes is not a good person, and referring to Miss Lively's reputation as a bitch. Although these statements were not made by Mr. Freedman allegedly endorsed Miss Kelly's comments and stated that she appeared to be a narcissist who could not accept how she's behaved and how she's treated reporters, and how she's treated people, and how she's treated individuals, how she's treated waiting staff and others, and saying it's not okay, we don't like you. I mean, Jesus. They continue to advertise all the organic reasons why people don't like her. And by they, I mean her attorneys, because they keep including like lists of reasons why people don't like her, or forcing other people to come up with lists of reasons why they don't like her, and then file it on the court docket so that they don't have their bank account information given up to a psycho. A March 19th statement to People magazine describing Mr. Reynolds' motion to dismiss as arrogant and stating that Mr. Reynolds believes that bullying is acceptable, and publicly documented to be a key player whose fingerprints have been all over this smear campaign against Justin and the Wayfarer team since day one. So the footnotes here are saying Miss Kelly is not subject to Rule 3.6 sanctions, and Rule 3.6 applies to statements by counsel, not a silent endorsement of a third party's comments. Also, that Mr. Reynolds is no longer a party to these proceedings. Now they're getting into the kind of legal arguments. Rule 3.6 is not an absolute bar to a lawyer's statements to the press. The first and fatal flaw to Miss Lively's motion is her failure to show that Mr. Freedman's statements will have a substantial likelihood of materially prejudicing the jury. Miss Lively does not even attempt to make this critical showing, asserting only a single conclusory statement. This court should impose sanctions here because Mr. Freedman's statements pose a significant risk of tainting the jury pool with deceptive, corrosive, and untrue statements cloaked with an illusion of lawyerly integrity. Miss Lively focuses solely on the ordinary prejudice that attaches to statements impugning a party's credibility, character, or reputation, ignoring the requirement that the statements must create a substantial likelihood of material prejudicing the jury. The authority cited by Ms. Lively in support of this theory is sparse and distinguishable. And then again, Mr. Freedman's statements fall within Rule 3.6's express exceptions. In fact, this court has recognized a lawyer's right to speak out. At the July 25th hearing on Liner Freedman, Tatelman, and Cooley LLP's motion to quash the subpoena, the court recognized an attorney's right in a high-profile case such as this to communicate with the press about court proceedings and the lawyer's interpretation, opinion, or spin on those proceedings. So they have a quote here. It says, "So if Ms. Garofalo leaves this courtroom and gives her spin on what I've said or what you said or what she said, that would be picked up. If it was Mr. Freedman who was here and he gave his spin, that would be picked up. Clients do have a right to have their attorneys speak to members of the press, particularly in a high-profile case, and give their interpretation. The public has an interest in that also. I wouldn't begrudge you speaking to members of the press, and I'm not going to begrudge Ms. Garofalo doing that. There can be no serious dispute that Ms. Lively and her lawyers, sometimes euphemistically called spokespersons, have disseminated a barrage of negative statements impugning Mr. Baldoni and the Wayfarer defendant's credibility, character, or reputation by alleging, among other things, that Justin Baldoni lied about his long-standing commitment to women's rights and betrayed victims of sexual abuse. On January 7th, Lively's legal team released a statement to E! News that this is not a feud arising from creative differences or a he said, she said situation. Sexual harassment and retaliation are illegal in every workplace and in every industry. A classic tactic to distract from allegations of this type of misconduct is to blame the victim by suggesting that they invited the conduct, brought it on themselves, misunderstood the intentions, or even lied. Another classic tactic is to reverse the victim and offender and suggest that the offender is actually the victim. These concepts normalize and trivialize allegations of serious misconduct. Media statements are not a defense to Ms. Lively's legal claims. We will continue to prosecute her claims in federal court, where the rule of law determines who prevails, not hyperbole and threats. In January to Deadline, they said, this latest lawsuit from Justin Baldoni, Wayfarer Studios, and its associates is another chapter in the abuser's playbook. This is an age-old story. A woman speaks up with concrete evidence of sexual harassment and retaliation, and the abuser attempts to turn the tables on the victim. This is what experts call DARVO, deny, attack, reverse, victim, offender. Listen, I'm so sick of people trying to use therapy terms like this. They are trying to shift the narrative to Ms. Lively by falsely claiming that she seized creative control and alienated the cast from Mr. Baldoni. The evidence will show that the cast and others had their own negative experiences with Mr. Baldoni and Wayfarer. The evidence will also show that Sony asked Ms. Lively to oversee Sony's cut of the film, okay, which they then selected for distribution and was a resounding success. Their response to sexual harassment allegations, she wanted it, it's her fault. They never said that. Who said that? Nobody said that. Their justification for why this happened to her, look at what she's wearing. No. That's ridiculous. They were talking about wardrobe for the film, you idiots. In short, while the victim focuses on the abuse, the abuser focuses on the victim. The strategy of attacking the woman is desperate. It does not refute the evidence in Ms. Lively's complaint, and it will fail. God, I forgot how stupid that was. Also in January to Deadline, Ms. Lively's counsel stated, any woman who has been inappropriately touched in the workplace will recognize Ms. Lively's discomfort. They will recognize her attempts at levity to try to deflect the unwanted touching. No woman should have to take defensive measures to avoid being touched by their employer without their consent. While they are focused on misleading media narratives, we are focused on the legal process. Okay. We are continuing our efforts to require Mr. Baldoni and his associates to answer in court, under oath, rather than through manufactured media stunts. So I'm pretty sure they're referring to that footage of the dance scene here, and this is just ridiculous. Any woman who's been inappropriately touched in the workplace. No. This was a scripted scene. She wasn't deflecting with levity. She was doing a bad job of being the lead actress in that scene. She kept trying to insert her own ideas instead of listening to the director. The next one says, over the next several weeks, we will move to dismiss the utterly meritless lawsuits brought against Ms. Lively and Mr. Reynolds. We will move full speed ahead with discovery that we expect will reveal shocking details about the depth to which defendants had sunk into their unending efforts to bury, ruin, and destroy Ms. Lively and her family. How's that working out for you? I remember this one. This was another Deadline article where they were like, what is Bryan Freedman hiding? After promising to release all the receipts, Freedman ran into court to keep secret the phone records of who Baldoni, Heath, Sarwitz, Nathan Wallace, and Abel were calling during their retaliatory campaign. Not only is this retaliatory campaign seeming more and more like a delusion, they actually ran to the judge to try to stop him from releasing this stuff. And then they were like, what's he hiding? Well, you told the judge to stop him from releasing it. The next one says, in its motion to dismiss, the New York Times correctly calls out Justin Baldoni's lawsuit for what it is, a shameless PR document that has no business in a court of law. For years, Baldoni urged men to listen to and believe women, but when a woman spoke out about his behavior, he and his billionaire backer Steve Sarwitz used a social media combat plan to scorch earth and try to bury and destroy her, along with the media who reports on it. These bullying tactics will not survive in court, and everyone should see their meritless claims for what they are. God, there's so much here. I can't read all of these. There's just so much. I'll skim through a couple more. In other words, in an epic self-own, the Wayfarer party's attempt to sue Miss Lively into oblivion has only created more liability for them, and deservedly so, given what they have done. Mr. Baldoni, Mr. Sarowitz, and team continue to turn a case of sexual harassment and retaliation into entertainment for the tabloids, going as far as suggesting that they sell tickets to a concert venue, Madison Square Garden, to witness Miss Lively's deposition, to subpoenaing Taylor Swift, a woman who has given a voice to millions the world over. How is that going? I agree, she's given a voice to millions the world over, but she wants nothing to do with your client. On May 15th, Gottlieb told Deadline, another day, another bogus filing designed for clickbait. What an asshole. They haven't just attacked Blake Lively and Ryan Reynolds, they have attacked the laws that are designed to protect victims of sexual harassment and sexual abuse. That was the one that pissed a lot of people off as well. I remember that. Because it's already been shown that she was at least less than 100% honest. And at that point, when people can look at footage and see that you weren't totally telling the truth, you should no longer be representing yourself as the face of people who were victims of sexual harassment or sexual abuse and act like you're doing anything for them. Miss Lively and her counsel also made efforts through widely disseminated media statements to alienate and sway potential jurors who might be among Taylor Swift's millions of fans against Mr. Baldoni and the Wayfarer parties. A Lively spokesperson told Deadline, we are pleased that Justin Baldoni and the Wayfarer parties have withdrawn their harassing subpoenas to Taylor Swift and her law firm. We supported the efforts of Taylor's team to quash these inappropriate subpoenas directed to her counsel, and we will continue to stand up for any third party who is unjustly harassed or threatened in the process. Is that a joke, lady? Be so fucking serious right now. You tried to violate the privacy of 107 people who are not parties to this lawsuit. Oh my god, you epic dumbass. And what a way to stick your nose in the asshole of someone who wants nothing to do with you. Just stop, bro. Alright, that's enough of the quotes for me. Rule 3.6 does not require Mr. Freedman to stand idly by while Miss Lively and her counsel conduct a transparent campaign to savage Mr. Baldoni, the Wayfarer defendants, and their counsel. To the contrary, the express language makes it inapplicable to statements that a reasonable lawyer would believe is required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client, such as the prejudice created by the incessant press releases and interviews published by Miss Lively and her counsel. Miss Lively conveniently fails to explain how these public statements differ from Mr. Freedman's. In fact, they are not. Like the statements Lively complains of, they challenge defendants' truthfulness, attacked Mr. Baldoni's character by repeatedly stating that his work to protect women was a fraud, and in fact, he is a typical serial sex abuser, and defendants are bullies. Unlike Mr. Freedman's statements, those from Miss Lively's counsel barely conceal their intent to taint the jury pool, particularly the millions of fans who follow and support Taylor Swift. Succinctly put, if Mr. Freedman's statements are sanctionable, so are those of Lively's counsel. Finally, implicitly recognizing shortcomings in its quest for Rule 3.6 sanctions, Miss Lively alternatively asked the court to exercise its inherent power to sanction opposing counsel. Miss Lively has not shown the bad faith conduct required for sanctions under the court's inherent power. Mr. Freedman's statements were made to counter the deluge of negative publicity spawned by Miss Lively and counsel as expressly permitted by Rule 3.6. Alright guys, if you want to read the entire document, you can go to this website, courtlistener.com, and then search up the Lively versus Wayfarer docket. Both sides have been aggressive with the PR, that's not surprising. But that's all I got for now, so thanks for watching, and I'll see you guys later.